Right. Very good afternoon, friends, colleagues, ladies and gentlemen. It certainly is a very lovely Wednesday afternoon, wherever you're joining us from. Welcome as you settle in this afternoon. On behalf of the East Africa Law Society and Beyond the Bar, we would like to welcome you to this very wonderful interaction that we're having this Wednesday afternoon. If you're joining us from across East Africa, please send us your shout outs on the chat room. Tell us where you're joining us from and how you are doing. And if you have a friend that you feel has to be here this afternoon, please share that link and tell them that our session is on. And welcome to our YouTube channel, YouTube family that is streaming at our YouTube channel at East Africa Law Society. Thank you for subscribing and for hitting that bell icon. Now, this afternoon is a very special one, like I said, and it's hosted in partnership with Beyond the Bar, an initiative that will be exposed on. But it looks at it's a platform really for meaningful discussions that on emerging issues affecting the legal profession and the wider justice sector, as will be introduced by the coordinator. But on behalf of the East Africa Law Society, we are glad to welcome you to this afternoon's discussion on AI in legal practice. And we ask a fundamental question there. Are you accidentally breaching data protection laws? Now, we know, honestly, AI has rapidly transformed our profession. It's no longer just a story, it's reality that is there. Everybody is increasingly using AI in legal research, in drafting, document review, client communication, and other professional tasks. And actually, as I speak right now, there's somebody who is listening to me that is using AI. That is how much AI is integrated in our day to day lives. And as we embrace these opportunities, we need to remain, alive to the associated risks, particularly confidentiality, information, personal data, legal, professional privilege, cybersecurity, and all those issues that may arise. So this afternoon's conversation is quite timely, and it should help us all to consider how we are using artificial intelligence responsibly, ethically, and securely while maintaining the trust placed in us by our clients and to the public. This afternoon, again, we are honored to host a very distinguished panel that will be introduced at a later stage, and the moderator will also be introduced. But on behalf of the ELS, we'd like to thank our speakers and the moderators and organizers, with plus you, our participants, for joining us this afternoon. Your continued support really reflects your hunger for learning and thoughtful engagement on AI in legal practice. Now, at this juncture, I'd like to hand it over to Shiba. Shiba, good afternoon. At one moment, we were a little worried that you were MIA, but it's good to see you. I'd like to hand it over to you to make brief remarks and introduce our moderator and kick off the session. So over to you, Shiba. Thank you.
Right. Thank you so much, Gabriel. Thank you for that wonderful introduction. Good afternoon, everyone. I am glad to have all of you here. My name is Ganyana Shibapasi. I am the programs coordinator at Beyond the Bar. And I'm just here to give you a brief introduction of what Beyond the Bar is about, because many of you have been asking. So before we get started and before I hand over to the panelists, I'll just like to introduce Beyond the Bar. So Beyond the Bar is an initiative that was brought up by Bridge Advocates Uganda and Trust Law Chambers. We wanted to build a community where we can be able to share knowledge and share ideas and build each other up, just create a network of lawyers throughout the region that go beyond the legal practice as you know it, beyond the regular desk research, where, you know, we are in a tech era, we are in an era where there's a lot of innovation going on. So we thought to ourselves, how can we come up with this platform that empowers lawyers to do more than the ordinary work they're used to, but to also contribute when it comes to innovation, when it comes to regional practice in the region. So that is what Beyond the Bar is about. And we have these monthly webinars. Every month, we always talk about a new topic and we do them in series. So we have a series every 3 months. This is the second month for our series, and we are focusing on tech and AI, and we'll wrap it up in September, of which in October we'll be starting a new series. So please feel free to email us if you have an idea, if you have a topic that you want us to discuss, if you are curious about certain areas in the law that you want us to expound upon, please feel free to email us, tell us your ideas. We love hearing from you, and we've been getting a lot of ideas from people. So please, you are welcome. So without further ado, let me introduce our moderator for today's session, Mr. Louis Muneza Lionel. He's an advocate of the High Court of Uganda with experience spanning commercial law, tech law, and dispute regulation. He currently serves as a legal service officer in commercial technology and regulatory affairs at the National Information Technology Authority Uganda, which is NITAU. He also advises on digital transformation initiatives, technology transactions, ICT regulation, and public sector legal frameworks. Beyond his public service role, Louis is engaged in private legal practice, advising businesses on commercial transactions, corporate governance, and strategic legal risk management. He's also the founder of a canine scent detection initiative focused on advancing security and public safety through specialized canine detection capabilities. So he's also an innovator, you guys. We are in the right hands. Louis is passionate about the intersection of law, tech, innovation, and national development. And he regularly contributes to discussions on emerging legal and regulatory issues shaping Uganda's future. I think he is more than capable of leading today's discussion. So let me turn it over to him. Louis, you're welcome. Thank you.
Thank you, Shiba. Thank you very much for the candid introduction. I hope I'm quite audible to everybody on call. Yeah, sure. Thank you. As I will not go much into the introductions, I have been introduced. Louis is my name, and I'll be your moderator today. I will be guiding much of the discussions and chipping in here and there, maybe to also give my view or perspective on some of the issues discussed. I have a panel today of 3 distinguished individuals. I will ask where I do go wrong on the introduction that I may be pardoned, or Shiba could come in and supplement. Allow me begin with Mr. Philip Chisaka, who is a Chief Privacy Officer with the Data Protection Office 360 Africa Limited. This is based in Kenya, Nairobi, one of the biggest economies in the region, you guys. So we are going to also get first-hand insight into how AI and data protection intersect, more so from his area of expertise and field of view. So he brings on board really the technical perspective on this discussion on how AI handles data, personal data, and different aspects surrounding due diligence and provider agreements regarding to how AI and data, personal data are handled. I also have with me Viola Musimire, who is a legal manager with the data protection. She's a data protection officer with Watu Credit, and also a legal manager with Watu Credit. She brings on board experience on because, as you agree, many people wonder what a data protection officer is. So she is one. She brings on board the experience on what the data protection officer is required of within the field of data protection, and from the side of the private sector. We also have on board Mr. David Bahige Motume, an associate with Trust Law Chambers and a lecturer with University of Kigali. He brings on board expertise with IP and data protection and technology law. He also possesses a master's in intellectual property from Africa University. I hope I have not butchered anybody's names or introductions. Where I have fallen short, Shiba could step in and assist. So again, like has been severally said, this afternoon we are going to discuss different aspects on how artificial intelligence and data protection intersect, or how the two merge, and the different rights, obligations of the parties involved, or the different stakeholders, and what is required of us. But to bring this discussion home, many of us use different AI tools to make our work delivery better, to ease efficiency. Many times for the researchers, AI sometimes helps you point your eyes to something that you might have forgotten, an area of the law that you might not have considered looking at. So many of us have used ChatGPT, many have accounts with Claude, and we use these to simplify or ease the way we handle our work, yeah? So this discussion might largely focus on lawyers and other private organizations, but I would like all other listeners on board to have more of a general, or we're going to try and make it a bit general so that we don't curtail it only to the legal profession, because I believe even people in procurements use AI and other, other areas of other professions. So without much further ado, I will begin with an opening question to the panelists, or I could, pardon me, we have two polls that we're supposed to run. I could maybe ask Shiba to guide, but maybe the first poll could be on how many listeners or how many of us have used AI to ease the delivery of our different tasks at our workplaces. So I will have another poll coming in that will feed into the discussions, but the listeners could on board come and give forth their experiences on the different AI tools they use and whether they do actually use AI. So the very first opening question, which goes to our panelists, but I will move from one panelist to another. Really, do most organizations and lawyers, whether primarily within the East African community, using AI tools, do they know that there is need to be compliant with the data protection laws? So Viola, you'll allow me to start with you. From the perspective of a data protection officer in the private sector, what actually do you encounter when dealing and interacting with AI tools at the workplaces? Like, what different tools do you use? What things do you encounter when you're dealing with AI and your field of data protection?
Well, in my experience, the honest answer is no. Most people and organizations are not aware that even with using AI, you're required to be compliant with the data protection laws. The problem is not deliberate, but most AI tools move faster than the governance that most companies have. We are seeing employees use AI tools for drafting, summarizing documents like you had mentioned. You find procurement teams onboarding these third parties using these AI tools, or maybe a data analytics team is using an AI for processing companies or organizations' data, but most people are not even aware of the compliance requirements that are attached to that. So the first question usually is, does this tool make my work easier? The data protection questions come in later, or they don't even come in at all. But from a DPO perspective, a data protection officer perspective, The difficult part is that the law does not become irrelevant because the processing has taken place through an AI interference. If personal data is being collected and stored or analyzed, the existing data protection obligations still apply. In Uganda, for example, the Act requires that organizations who are processing data process it fairly and lawfully and only collect it for a relevant or a required purpose. But those questions do not come into most of our heads when we are going to have this report entered into a system like Claude to generate a report for you, or an analytics system, which breaches the data protection platform. So I would say the biggest gap is not necessarily using them. The biggest gap is unawareness or an operational unawareness of using these AI platforms. Organizations therefore need to move from the question of can I use AI to a more mature question of what approved circumstances can employees use AI, and what tools should we use subject to what controls. Over to you, Lois.
Yeah, thank you, Viola. I do agree with you also from the regulator's perspective. I think we shall come to it, but awareness is a big deal. So many people ask, even with the regulator, if what I have is not, if I'm not going to commit crime, if I'm not going to do anything illegal, then why should I be protecting data? So people have that kind of mindset. They don't see the black gold in data. So I do agree with you. So anyway, from again your experience, Viola, when of course we've appreciated that awareness is also a key issue, but when and where does the compliance aspect break down? Like, for example, if I were going to upload information on different, say, recruits, yeah, for example, what we limited if they are going to say recruit people, and they have so many 1,000 applications have come in, and somebody wants to sift through that data so fast, yeah? Can't they, at what point do you think the breakdown in compliance begins? Is it at the point when they get all this information in soft copy and throw it at the AI analytics tool or chatbot and then wait for it and give it a commando prompt to, sift through the data the way they want it? At what point do you think that breakdown happens?
Well, the first thing I would say is that even though the employee may see it as a harmless administrative task, the moment an employee uploads identifiable customer information into an AI platform, that information is being processed. So under the Uganda Data Protection and Privacy Act, processing is defined broadly. It includes retrieval of information, consulting, transmitting, or even disclosing this information to another party. Therefore, it's not just merely using a software tool, it's now a processing activity, which would mean we would have to ask ourselves a few questions. For example, what data is being uploaded? Was it simply a request for a generic document? For example, draft for me a generic document to notify third parties that their contract has expired, or you have procured the contract with a third party with say the name, the passport IDs of the directors and the shareholders, and also sometimes the bank details of these shareholders, and you've uploaded everything to an AI. Then we would look at why is it being uploaded? Was there a legitimate and documented purpose for using AI? The organization should be able to connect the AI processing to a defined business purpose. Uganda's law require fair and lawful processing, and limits further processing to a specific purpose for which the data was collected. Imagine a company that provides online loans. You gave it your name, your national ID identification number, and then you also provided a picture. So they mentioned that they obtained this information to process your loan. However, you later find out that they are using this information sometimes to advertise your name as a defaulter. So this is the use of information beyond the required purpose. You then look at the agreement you have with them. Was this disclosed to me that my personal data, my photograph, would be used for an advert, probably in the newspapers or on social media platforms? So we have to restrict ourselves to why was this data uploaded? Then who received the data? Going back to the example of the lawyer who uploaded the contract with the full names and details of the directors and the company and the bank details of those directors. A lawyer did this to save time, or it could even just be an individual. They did this to save time. Probably you're a tenant, you got this agreement and you figured, I can't read this 5-page agreement. Let me upload it to ChatGPT to highlight the risks that are attached to this agreement. But remember, this contract has your name, your address, where you're going to be staying, your account number, even your telephone number. So it feels like you're just getting a quick result, but this is not necessarily what just happened. The moment the document is uploaded, the information may be transmitted out of Uganda, out of the law firm. Even most service providers, AI service providers, use other service providers to process their information. Probably you've seen AIs like Copilot associated with Microsoft or other AI service providers, but you've not taken this into consideration. So the passport number or the bank details of that person that contain your information or even your signature no longer seated within just a paper. They are now in the cloud. And those are the questions we should be asking ourselves. Then where is this data going? If the AI service provider processes or stores the data outside Uganda under Section 19, this becomes relevant because the law requires the controller or processor to ensure that the destination country has adequate protection equivalent to Uganda. And sometimes our company may highlight and say we are compliant to the international data protection laws, but remember there are requirements for Ugandan data protection. We've seen a very big social media company that was taken to court because they were not registered with the Data Protection Office, which would mean they're not compliant with Section 19 regarding the transfer of data. So those are questions we should constantly ask ourselves. The last question would be, what happens to the information after this prompt? Let's take the example of the lawyer who uploaded the contract or the tenant. The lawyer will type, please review the contract and identify the legal risks. But from a data protection perspective, that is actually the moment when this data could have been stored on these service providers' platforms for, say, 30 days, for 6 months, or even indefinitely. So we should ask ourselves, what happens to this information after we've given it to them? If I write an email and ask them to delete my data, do they delete it completely? Have we looked at maybe their data privacy notice on deletion, or we haven't looked at that? So those are some of the considerations we should consider. Over to you, Louis.
Thank you, Viola. And just one last thing, again, from the perspective of a data protection officer, do you think organizations can adopt any internal, could they say, like working policies in regards to how staff can safeguard client personal data as they interact with AI tools, as we go about working for the different organizations we do work for? And there are some internal policies they could adopt that could help manage how we, the employees, handle the data of our clients. Thank you.
Yes, actually, I believe this can be done. We could look at the process of how this can be done. So AI tools could be identified. Who is the user department? What do they need this AI tool for? Then we would screen the risk. What is the risk attached to it? Is there a sensitive personal data that is going to be uploaded onto these AI platforms? Is there financial or biometric data that's going to be attached to these uploads? Who will influence the decision making? As we are all aware, in Uganda, a service provider is supposed to inform you, or an organization is supposed to inform you when they're going to when they're going to upload your data to an AI platform, which is going to make the decision on behalf of the organization. That way, the person whose data is being used to make this decision has avenues for which to appeal against such a decision that has been made by this AI platform. So such risks should be screened by the data protection office of the organization. Also, it would be advisable to conduct a data protection impact assessment where the risk is very high. And this is also provided for under the Data Protection Act. So this would entail finding out who would be affected by this sharing of data. Is there a high risk to sharing this data, and how can this risk be mitigated? Can we annotize people's names? Can we probably delete the pictures and only attach the relevant information? So all of that should be considered. And then we would also look at the lawful basis of adopting these tools. That would mean we consider the consent that has been provided to the organization, not to the person that is uploading these tools. Then we would then look at approval of this and also periodic reviews. Has the general management of the company approved this? How often will they be reviewed? Because as we notice, each and every day there is a new AI that comes on board. And if we don't streamline what AIs can be used and how, then you find organizations and people in general just using any AI without screening for these risks and understanding the AI service providers' data processing agreements.
Thank you very much, Viola. That has been very insightful. I guess a number of other data protection officers in call are auditing themselves based off what you have shared with us. Philip, hi.
Hello, hi.
Hey, hi, Philip. How are you?
Doing good, doing good.
Good, good. I am turning to you. So I, for one, have created a master profile before and uploaded it on AI. For those wondering what a master profile is, the master profile covers pretty much everything about yourself, your name, your email address, your interests. And the idea was I wanted the chatbot to respond to my issues with a personal, how do I call it? For lack of a better word, personal touch, not to give me generic responses. So, Philip, I just wanted, using my own example, where do you think that data goes? How is that data handled? Like, for example, now that I had uploaded it to ChatGPT and Claude, for the listeners on call, where does such data go?
All right, thank you. Thank you very much for your question, and thank you to the team that put this very comprehensive conversation together. I'll jump straight into it. You look at the way chatbots and the so-called AI, and to the ordinary listener or viewer, if you ask them what is the definition of AI, they definitely move to say ChatGPT being the most common one, and of course Claude also being the most reliable one. In fact, there's a running joke that Claude and ChatGPT account for more than 80% effectiveness of staff nowadays in different organizations. So you've seen a number of times when Claude is down or when ChatGPT is down, most people find it very hard to deliver their jobs. But of course, one of the most common prompts that we normally input in these platforms is that do not make generic. Or as you said, you would put in some background information and give it a lot of context, and then say, now based on this context, I want you to generate for me an answer. So effectively what happens is that when you input this prompt, by default, and assuming I'm talking to a crowd that is comprised mainly of lawyers, by default, this request is sent to a third-party data processor. So the first party being the data subject themselves, the second party being the organization which you represent or which you work for. And now we are calling this a third-party processor because it is not in the ordinary purview or assumption of any customer or data subject, ideally, that you would put their data into Chat or into Claude for any further processing. So when that request is sent to the third processor, this effectively is already what we call cross-border transfer of data. And it's cross-border transfer of data. I know the Kenyan regulator the other day issued a guidance note on cloud storage of personal data. So ideally, the way these systems are tailored or are wired, they utilize cloud storage with the physical servers that are attached to these cloud storage mechanisms that are not located within the East African region. But also what I want to call to attention is that East Africa is not uniform in terms of application of data protection regulations. In fact, there I say that Africa is not uniform. And so even as we talk about East Africa, of course, there are times when there are certain nuances that have to be looked at differently. So, and then once this request is sent to the third party, what happens next ideally depends on whether you're using a free tool or you're using a consumer-grade chatbot, or you're using a tool that you have actually paid for, an enterprise grade or one that has API integrations into what you're doing. I know there's a very popular common legal tool called Harvey AI. It's quite pricey. I've seen a number of top law firms use it across the region. It's quite pricey, but this is an enterprise integrated AI tool that allows for legal research, drafting, and the whole entire ecosystem. So if you're using a free tool, the next question is always, have you read the terms and conditions for you to use this as a free tool? Remember, it's nothing that is given out for free. Anytime you interact with anything that is given for free, you are the product. And therefore, on a free consumer-grade chatbot, then this input may further be logged, retained, and in some cases, it is also used to train or evaluate the model, which means the model will keep learning from the data you have inputted. So you might put a client list, and the client list has various identifiers to the extent that when someone else is using the same free model from a different country and they input the name of Philip Kisaka from Kenya, they're able to get precise information about them that was inputted by another AI user in a different region. Of course, when doing this, we would probably advise for you to use enterprise or API tiers. And these have to be backed with the right contract, that you can actually say that we have this contract with this provider. Our data should not be used to train. You should also define the data retention commitments. One of the principles of data protection is the principle of storage limitation, such that this data should not be kept indefinitely. And therefore, definition of all these things that we have come to know as the principle of data protection should be done ideally within this contract. And this contract is also what we commonly refer to as the data processing agreement. So most people using these tools today are using the consumer tier. without really realizing that there's a difference that exists. So it's a stark call to all of us to just try and figure out, one, are we using the paid version or unpaid version? And even if you're using the paid version, the one that you have paid individually per month, again, there are those versions. You need to also further go down and read the terms and conditions and satisfy yourself that if there's anything that was switched on by default, then you have switched it off. And by default, I mean things to do with training or retention beyond reasonable timelines. Thank you.
Thank you very much. At least you've touched on a number of areas that I wanted to follow up on with some questions. But briefly, what are those generic terms and conditions like? Because many of us just click accept, and we move on. But usually, what do those generic terms look like? Usually, they're standard form. Many people don't get to negotiate around them. They just accept and move on. But for the listeners, what do they look like, those generic terms? Thank you.
Of course, in this ecosystem, there's a lot of information asymmetry and power imbalance. What do I mean? I mean that OpenAI is not about to respond to a request by Philip Kisaka from Kenya, who utilizes 0.00001% their capacity. And therefore, it is in times such as these that we need to be very careful with what models we use. The power imbalance exists because there's a way these systems operate, number one. And number two, for them to realize profits or to realize returns from them, they need to almost operate uniformly across different jurisdictions and different groups and categories of people. So as you rightly put it, it's very hard to negotiate these kinds of contract. And that's why I began by saying that there's an alternative. Is the free tier. There's the option of the one that an individual pays. And then there's the enterprise grade tier for most of these tools or API integration into existing company enterprise resource planning tools or company systems. And so negotiation mainly would come in if you're approaching this as an organization, as a company, as a large player. As I mentioned, there's the Harvey AI that's supposed to be used by lawyers. And I know the pricing around that thing is crazy per individual seat. And therefore, it effectively locks out a lot of people from that ecosystem. So you look at some of the standard contractual terms or standard terms in these terms and conditions in these AIs would be, if you're using the free version, it's impossible for you to switch off the training module that this platform purports to use. Therefore, as I mentioned, if you're not paying for something, then ultimately you are the product. Number two, it'll be around things to do with storage limitation. Now, storage limitation, again, if you're using the free version, you have very minimal control over how long these platforms will definitely keep your data. Another principle is the principle of purpose limitation, which of course is linked to what I've just talked about. Over and above training the models, the purposes with which they can use this data are exponential. And it is very hard for you to, again, regulate this because the trade-off you have given is the free version for you to give out your data for use. So it's very important for us to have a balance. I think as a mitigation measure, because it's not fair to leave everyone just hanging with, don't do this, don't do this, don't do this. I think the proper mitigation measure would be to try as much as possible anonymize data before you run it through AI, especially when you're not using enterprise grade subscriptions. So what do I mean? You have a client list or you have data that you want to sift through and you want some form of analysis. You can start by removing identifiers and pass it through AI with pre-generated identifiers. And then once it has done the analysis, then you can reintroduce the identifiers to already analyzed data. I think the problem here is that AI has made very many of us, very lazy to the extent that we find that as a lengthier process and we want, instant coffee, copy, paste, generate, do some 2-3 runs, walks, come back, it's generated for you, submit it as a report. Yeah, thank you.
Thank you, Philip. Going over the generic terms, and definitely not just the generic terms, but the entire scope of the terms of use. What other areas would due diligence cover? And also briefly, you could tell us what you understand or what entails the privacy by design. What does privacy by design entail? Thank you.
All right, due diligence with this kind of platforms. Number one, I would probably look at things to do with where they purport or they claim their physical servers are located in. So as you know, with every cloud platform, there's definitely where the physical server location is. It's very important for you to know, one, is it a region that has high proclivity to data breaches? Do they even have a data protection regime? Or is everything just left to chance? Of course, the best region right now, and I don't want to say it's a gold standard, but it's being used as a gold standard, is the European Union. So within the European Union is almost considered just about to be okay. But of course, the Ugandan regulator will disagree a bit with this. I know Google and Meta mid-2025 were ordered to comply with the transfer rules, because they failed terribly at demonstrating that they had put adequate safeguards in place. So that would be the first thing. The second issue on due diligence would be to look at, especially for enterprise grade subscriptions, is to look at whether it is easy to reach these platforms. So do you have a sales representative, or do you have sort of an account manager who you can quickly reach out to in case of any issue failing? But of course, that is very expensive. And so my default position would be this. If you're an individual lawyer, small law firm, boutique law firm, startup, the best thing to do is, one, you can use the paid version, but number two is also to switch off those permissions for training. And number three is to try as much as you can not to input personal data into these platforms. They're powerful, they're very good, but then the potential for misuse is very high. So there are very few things you can do as an individual. As an enterprise, you have a negotiating power, especially based on the amount of credits and queries you do make. You have asked the next question on what I understand by privacy by design. So essentially, privacy by design always goes hand in hand with what we call privacy by default. Privacy by design, in a very simple sentence, is inputting privacy or data protection measures at the start of a project or at the start of a system or software before it is deployed or it is released out to the public or to their respective data subjects. What do I mean? I mean that there are instances, and this we've seen in many organizations, that data protection is considered as an afterthought. And so someone will build a good product, build up a marketing case for it, build up a business case for it, get ready to deploy, and then figure out, oh, we have a data protection officer or department. How about we ask them for their go ahead? And normally it's never a consultation on should we do this. It is always a consultation on we are doing this. Please sign here. Please sign here. So it becomes akin to just rubber stamping something that has not yet been analyzed for privacy safeguards from the very beginning. So privacy by design would look different or differently from organization to organization, depending on what you're doing. For a technology company, before any technology is designed, the privacy team should be involved at the conceptualization stage. For a marketing campaign, for instance, the privacy team should be involved in how the campaign will run, what documentation is needed to either seek consent or notify the data subjects. So ideally, privacy by design is embedding privacy right before the project is even kicked off. Then privacy by default, which goes hand in hand with privacy by design, and I was not asked, but it's very important to also bring it into context, is that the default setting or the default assumption in any system, project, process, program is that the data subject has asked for the highest level of privacy. I'll take that one more time. Privacy by default simply means that by default, as a standard, the data subject has asked for the highest level of privacy. And in the event you want to either compromise on this or offer a lesser level of protection, then you ideally need to seek out their consent Or number two, they need to carry out a proactive measure for them to allow you to do a certain thing. I'll give you an example of the mobile phones we use nowadays. I use an iPhone. So you'll figure out that every time you download an app from the Apple Store, what happens is that once you've installed it and you have just started using it, it will always ask you, do you wish for app to track your, I think, location or something of that sort. And then there's a button that says allow and do not allow. So that is what it means to have privacy by default. That the default setting is that it assumes you have not given it permission until you actually proactively give it permission. Thank you.
Thank you very much, Philip. Thank you for your very detailed discussion, and thank you for the insight on what happens back end to all this data we feed these AI tools. Allow me move on to our third panelist, David. David, are you there?
Yes, I am.
Yeah. So, David, our discussions are really going to focus more on the legal profession, and you'll give us a few of insights from the Rwandan legal profession or legal sector. Largely, majority of the data we feed these AI tools, or many times when we have having client consultations, the information we get from our clients is privileged information. Yeah. So at the point where I upload this client's information into an AI tool, because either I want it to summarize it, or maybe I'd want it to analyze it, or maybe give me another, perspective that I might not have, given thought to. Do you, in your opinion, think that this raises issues to do with privilege? Like, have we breached that duty of confidentiality and privilege when we now involve this third-party AI tool? Thank you.
Thank you very much, Louis. Thank you to all who have joined in and are listening. Again, my name is David Bahige Mutume. I work with Trust Law Chambers. Maybe just to also give a small background, I don't know if I'm releasing any personal data here, Louis, but me and Louis have been colleagues since nursery school. So it's nice to see that you are sitting on the regulator side and I am here trying to make sure that what I say is in line with compliance, right? So again, I will restrict myself to Rwandan perspective, and Louis will correct me in case I mention anything Uganda related that is not current. Yeah, but thank you for the question. I think the other thing that maybe we need to clearly distinguish between data protection and privileged conversations or professional secrecy, which is what lawyers are required of from their clients, is that the data protection law does not in any way govern or regulate those privileged conversations. That is a principle that has governed our profession from time immemorial, and up to now, it still stands. The fact that you should keep client information confidential is one of the most common clauses of the engagement letters we sign with clients, and that is no problem. The difference is that not all confidential information should be considered as personal data. I don't know if that makes sense. And not all personal data should automatically be taken as the privileged and confidential information. Confidential information many times is governed by non-disclosure agreements, by again new engagement letters, which go ahead to also define what exactly we mean by data. I mean, what we mean by confidential information. Now, the only way that you as a lawyer, you are allowed to share confidential information with a third party, and in this case, it might be an artificial intelligence tool such as ChatGPT or Claude AI. The only way you can do that is if you have permission from the client to actually do so. And one of the main principles, and not to confuse you, But one of the main principles of data protection is to ensure that you have consent from the data subject. So once you have consent from the client, you have ticked both boxes. But the question is, by giving you such consent, have they waived that information being shared with third parties? By giving you permission, for instance, to disclose, have they made sure that you, as the lawyer, you are compliant with data protection laws? And I believe not. Yeah, because again, compliance with data protection laws stretches out much more, and it's not just about confidential information. Compliance with data protection laws, as you're aware, requires registration. Some of these things have already been mentioned by the people who have spoken before me. Viola mentioned that the fact that you must have a basis, a lawful basis. Under the laws, I'm sure even in Uganda, it's still the same thing, but there are particular grounds under which you are allowed to process personal data. They include consent of the data subject, they include necessity of a contract, they include legitimate interest, they include in situations where it is required by law. Yeah, so you still have to meet those. You can't, just because the client has said it is okay, and just because you feel that it is faster to use an AI system, still does not make you compliant, right? So we have to still make sure that law firms are registered. Now the question is, registered as what? Do you register as a data controller? Do you register as a data processor? My answer to that question would be, you have to register for both. Now, in situations whereby you are the one collecting the data from your client, you're the one determining what to use that data for, because you're probably analyzing it in order to provide a legal opinion. In such situations, realize you are the data controller, because that's what the definition of data controller is. You're the person who collects, you're the person who stores, you're the person who determines what the data is used for. All these other principles relating to retention of the data, the third parties, whether you are making sure that you're in line with cross-border compliance requirements, is all on you as the data controller, and that makes law firms a serious data controller. What's even more important for law firms to understand is that we deal with a lot of sensitive data, sensitive personal data. Sensitive personal data is a special category of personal data. It includes things like the criminal records of individuals. It includes health information about individuals. It includes information about your sex and your family. That is sensitive information. If you're a lawyer out there and you're working on a divorce matter, you realize just one file like this contains all that sensitive information, correct? So can you just upload it onto an AI tool? Maybe, because there are certain restrictions when it comes to sensitive data. Are you following those requirements? Because the law is not saying that you cannot handle sensitive personal data. It's simply saying that you can handle sensitive personal data, but you must make sure that you comply with certain requirements. And I think that's an important question that you must answer. Now, when that is about controlling, you as a law firm, you're controlling personal data. When it comes to receiving instructions, for instance, many law firms are acting simply as company secretary for certain law firms. I mean, for their clients. Certain law firms are handling the human resource function of their clients. Some people are just handling a particular function on behalf of their client. Meaning, even in those scenarios, you're dealing with personal data. But the question is, are you dealing with it as a controller or as a processor? Because your client is the one that collected the employee's name and you're the one drafting that employee's contract, you realize that your law firm is acting as a processor. So the question is your law firm registered as a processor? I know the questions, the answers that people are expecting to hear right now are things like, is Claude AI compliant with data protection in Rwanda? Can I use it? Is ChatGPT compliant with data protection laws in Rwanda? Can I just use it? That would be a simple answer to give, but I do not represent any of those people, and I would not like to speak on their behalf as such. However, what I can tell you is how to look out for whether they are in fact compliant. I think the question that you asked, Viola, regarding policies, just like you're mentioning, just like we keep on mentioning that people must have, companies must have data protection policies. It's very important for law firms to have data protection policies, and on top of that, have AI policies as well. Because the AI policy should be the one that helps you to determine the particular type of tool that you use. Whether you choose, for instance, GPT over Claude, those are all questions that should be answered as a law firm, and not just you as the individual law firm. As the individual lawyer within a law firm. And having to come up with a policy is one of those scenarios that will allow you to have a conversation on all those aspects. Maybe also another thing that I would like to mention, and in line with what Philip was talking about, it's very commendable for the Kenyan Commission on Data Protection to have released their guidance note on cloud storage. I think that is very important, especially for artificial intelligence tools, and understanding whether they are compliant. Because one of the biggest problems that we now realize, and one of the biggest questions that many of you may be asking is, okay, yes, David, you've told us that law firms must register, but we're dealing with ChatGPT. Is OpenAI registered as a data controller or processor in Rwanda? Do they have to register? What about in Uganda? Does Claude AI have to register? Are they registered? What are their data protection agreements saying? Have you read them? You asked Philip a question about what are some of those terms that are and Philip may go ahead and tell you what they are currently. But those terms as they sit now, we all know that they will change in not less than 6 months, or even less, because we know that those terms and conditions keep on changing. You as the law firm, you're supposed to keep track of those terms and conditions. He mentioned tiers versus API use versus enterprise. Do we understand what that means? For instance, when we talk about tiers, from my understanding, I believe we're talking about subscription-based, so subscription types. Are you using an individual free subscription? What we know, and the most common caution that they will put, whether using Gemini, whether using GPT, is that we shall use your data to train our model. Google is clear. They say that they will use, there will be human reviewers who will look at your data and use it to train their models. Aren't you breaching data protection laws by using a free version? What about the paid version? Philip mentioned some things like settings. Do you know where the setting to turn off and turn on, whether they should use your data for training? Do you know where that setting is? Have you tried to look for it in the version of the tool that you're using? That's an important question. Have you tried to compare the terms that an individual paid for subscription on Claude offers in comparison to an enterprise version of Claude? Because from what I understand is that if you use Claude Enterprise, your data is not used to train their model. But even if you're on a paid version and it's individual, I think it's upon you to look for that setting and change it. You may correct me if I'm wrong, because I know many of you use these tools, and depending on the tool that you use, you may be much more aware of these settings than I am. Yes, but now when it comes to APIs, are you running the tool on your own servers, on your own hardware? That's also a different question. Does it then make you think that, oh, there are some technical persons that we should involve in this conversation as a law firm to help us understand what our AI policy should involve? I think yes. I think it's not for us to help you understand whether Claude is better than GPT. What I can tell you for certain is that law firms are data controllers and are data processors. Law firms have a huge risk because for them, they deal with special categories of personal data. Those special categories of personal data carry larger cautions. They carry larger sanctions. There's more money involved. Does your professional indemnity does your professional indemnity actually match the amount of money that may be fined by Lewis, the regulator, in case he catches you? These are all questions that we must ask ourselves. But to simply answer your question, I think it's important that we, first of all, separate the question of professional secrecy, because that one is a given. It's the normal way of business. And then ask yourself, in the information that I am about to share, yeah, considering that it is confidential, do I have the consent to do so? If I do not have the consent to do so, how do I avoid breaching personal data? Philip mentioned redaction. It doesn't take so much time for you to get a document or your question, put it on the site, and before you upload it, change David's name to John Doe or XXX. Remove his ID number, remove his telephone number. That doesn't take a lot of time, and you will still be able to do it efficiently. When it comes to professional secrecy, I think another point that I am forgetting, and which is important for law firms, is disclosure. Yeah, because as lawyers, we are slowly getting into the habit of letting people know that we actually use AI. But because you're scared of how people will look at you, or how they will gauge your work and say that, oh, that one uses artificial intelligence. Is it wrong to use artificial intelligence? I know those are all questions still at the back of everyone's mind, and it's allowed, very much allowed. But as far as breaching the law is concerned, privacy is concerned, I think the first step towards getting consent of a data subject is simply disclosing that you actually use artificial intelligence. It doesn't take away anything. You can include this in the terms and conditions of your engagement letter. You can include this in your AI policy as a law firm, so that the people that you deal with are already aware of this, right? So there's different ways of handling it, but the first step is to differentiate between what is confidential and what we are considering as personal data. I think once you do that, then you stand a chance of avoiding any sort of breach. Yeah, I've really gone around, but I hope I've answered the question.
You have raised a number of thought-provoking things. I, for one, have been scratching my head there thinking, early in January, there's a small law firm I started. It's there
I
on
know.
a Conrad Plaza. It's doing its best. I hope it will be like Trust Law Chambers one day. We're still earning the trust from people.
Yeah.
So I was wondering, what obligations do you think, for example, Mike, a small law firm, would have to undertake in terms of ensuring that because already we have come to understand that we are data controllers of sorts. By virtue of the fact that I have gotten information, I have not yet started to either process it in terms of sifting through it, doing research and things of that nature. But in as far as we are data controllers as a law firm, what obligations do you think we need to take into regard to protect this personal data that comes into our our trust? Yeah. And I think the very first one you had talked about was disclosure. You could just bullet out for us the rest, so that the other listeners and other small law firm starters like myself can.
All right. Thank you so much. And I think that's where I should have even started from, because I don't know why you're mentioning. You keep on hinting to small law firms, but I'm going to push back on that and say that the requirements and compliance with data protection laws affect even individuals. And I understand that there's many one-man chambers running around the streets who may think that this does not apply to them, but even the sanctions provide for where it is an individual who breaches the law compared to where it's a corporate body that breaches the law. Yes, the punishment might be different, but they envisage such a situation. So it's not just for small law firms. Now, I think, in my opinion, the main and very first thing that you need to do is register. I understand, Louis, you as a regulator, you know that when someone comes into the process of registration, just by mere bringing themselves that they have come to register and they fulfill all the requirements for registration, they are already bringing themselves into to compliance with the law automatically. So the first step is simply register. Once you register, of course, NCSA, when I say NCSA, I refer to the National Cybersecurity Authority of Rwanda, which plays the same role as NITA Uganda. Of course, under them, there is a data protection office that actually regulates, but when we are referring to any of these, we say it is, I'm seeing a hand up. I think it's Shiba, you can.
Yes, Shiba.
Okay, maybe it was a mistake. Yes, so when we're talking about NCSA as well, when they ask you to register, they're going to ask you for a number of things. They're going to ask you whether you have a data protection policy. Do you have one? As a law firm, you cannot complete registration unless you have one. Do you have a data retention policy? What does your law say about? I don't know currently what the law says about retention in Uganda. I understand it might be 7 years in Kenya. Philip might correct me, but I know for Rwanda it's a different scenario. For Rwanda, it simply says that you keep data for as long as you continue to do the purpose you collected it for. What does that mean? That means that if that purpose is complete, you are not allowed to keep this data anymore. Of course, depending on your data processing agreement with different third parties and clients, that might change. And because of the type of data involved, you might find another regulator, like the central bank is involved, and there's other regulations on how long you should retain financial data. You must make sure of that. That's true. But you need to have this policy. You as a law firm, how long do you keep people's data? Yeah, that's a retention policy. What about data sharing? Do you have a ready non-disclosure agreement that you normally sign with your third-party providers? And we have so many third-party providers, by the way, because as a law firm, you may have to translate. As a law firm, you may have to involve a courier. As a law firm, you may have to involve a technical person, for instance, to do something that yourself you cannot do. This involves other third parties. Are they handling any personal data? Do you need to have agreements with them? Those templates should be ready. And even when you're applying for registration, you realize that's some of the information they ask you for. Now, that's registration. And registration is the main first point. The second point that I want to mention is basis, a lawful basis. Normally, you refer to this as, do you have a ground for processing the personal data? In other words, NCSA or NITA Uganda is trying to ask you, where are you collecting this personal data? Is it actually necessary? And we know that there's a lot of people out there collecting personal data for no reason whatsoever, keeping it for a long time for no reason whatsoever. So the law is making sure that we have particular grounds that we must adhere to. For instance, the first one is consent. Data subject consent. That one is the most obvious one. And I say that one connects to my earlier point on disclosure. By requesting for consent, you are essentially disclosing to your client that we may use your personal data for this and this purpose. And therefore, we want to know whether this is acceptable. I know automated decision making is a topic for a later question in this webinar, so I won't speak on that, but it relates to the same. So one of the most obvious grounds is consent. You may not have a contract with the data subject. You may not have a lawful basis. You may not have a public interest that you're trying to solve. However, you can have simply the consent of the data subject. That on its own is one of the most strongest grounds. Again, how do you do that as a law firm? Include it in your terms and conditions when it comes to your engagement letters or in any other way that you relate with your clients. I think disclosure that you use artificial intelligence as a law firm is going to become an important aspect of the future. When it comes to, maybe I should also mention that that Rwanda has a national artificial intelligence policy. I think it's one of the very first African countries to have a policy and strategy. It was I think it was passed in 2023, if I'm not mistaken. But some of the activities that are given to the National Cybersecurity Authority, they assure you where we are going as far as artificial intelligence is concerned. And this touches on the same thing, the guidance note that Philip mentioned, the guidance note on cloud storage. Because the NCSA is going to start to review both local and foreign cloud storage providers. So do they adhere to the data protection laws, to the personal data protection laws of Rwanda? Remember, this is the national AI policy. It's looking forward to cater for personal data, and especially when it comes to cloud storage. They're going to audit these cloud storage providers, and it will become easier for you to know that, oh no, this is an authenticated or a verified cloud storage provider. So in the future, it will be made much easier. But for now, we don't have that as yet. And this is a policy simply talking to where we're going. So for now, the best way to protect yourself is to make sure that you yourself are in charge of how you handle the data. And how do you do that is ensure you have agreements with everyone you work with. So that's the third point that I want to make. As we started from registration, we went to a lawful basis, and now I'm mentioning that you must have a contract. There's always need for a contract. Philip mentioned that these are normally referred to as data protection, data processing agreements. Even within the terms and conditions of Claude, even within the terms and conditions of OpenAI, ChatGPT, you must look out for the data processing agreements. This is where they mention many of these things that I'm hinting on, such as retention, such as whether you should register or not. And I think you should also consider that. I think the last thing would be logging. Yeah. And I think, I think before that, I should mention cross-border practices, because this is also something that Philip hinted on. For any law firm, you must understand, because we deal with a lot of foreign clients, you must understand what compliance means when it comes to handling of personal data from a cross-border perspective. I understand that most East African countries, and correct me, Louis, if I am wrong, but most of the countries in the region simply say that in order for you to lawfully transfer your data outside of the country, you simply need to make sure the country that you are transferring or sharing that data to has similar, if not better, safeguards when it comes to data protection, which is, I think, much easier to comply with compared to where I'm currently sitting, which is, for instance, in Rwanda, it's different, and they say that you cannot transfer data without authorization of NCSA. So yes, you may know the country where you're sending it to. Yes, you may know that that country uses the GDPR, and yes, you may know that the GDPR is sort of in line with your own data protection law, but it doesn't matter, because in order to transfer data outside of Rwanda, you still have to seek authorization from the NCSA, which is different. If you want to store data outside, again, that's also another type of authorization. So you might find yourself in Rwanda trying to be compliant, and we're asking you to have 4 certificates. A certificate of being a data controller, a certificate of being a data processor, a certificate authorizing you to transfer data outside of Rwanda, and a certificate authorizing you to store data outside Rwanda. Then lastly, when it comes to cross-border data, I think we shall even talk more about it in the webinar, so that's no problem. But lastly, I think the last point I want to mention is when it comes to records, right? Logging. Logging is one of the requirements in the data protection laws. You must keep track of who you share data with, where you got it from, who has access to it. And when it comes to now artificial intelligence, which tool did you use for this particular purpose? Which tool did you use for that particular purpose? And this all matters as long as personal data is involved. I think we shouldn't forget that we are not talking about all types of data. We're simply talking about data that can be used to identify a person. And that's what personal data is. Yeah, so as far as what can a law firm do, I think those are my 5 main points. Registration, lawful basis. Do you have a contract with third parties? The 4th is, do you understand what cross-border data handling means in your jurisdiction? And then lastly, are you logging all this information when it comes to how you're handling the data.
Thank you very much, David. Thank you for that very insightful guidance. I'm going to make sure that I am compliant. I know it sounds funny coming from me, but it is what it is. So, I just wanted to shed light on what you were saying in terms of cross-border management. So, from the Ugandan side, I came to understand that we also kind of categorize data. You'll find that financial records are seen to be more sensitive data. So for you to, the Bank of Uganda regulations require that for you to externalize somebody's financial records, and now this is an obligation they place on financial institutions and fintechs, they have to get authorization from the Personal Data Protection Office. That is for that kind of, allow me call that data set, the financial records and things that can identify somebody within the confines of finance. Then the other is really seeking consent of the data subject and conducting what we call a, pardon me, let's get the right term. Yes, an adequacy assessment, yeah. So now that one is an obligation on the person externalizing data. You need an adequacy assessment because whereas the law provides for consent, you would agree with me getting consent of like 2,000 people is a tall order. So an adequacy assessment would cut. So would cut it. So that is how things are handled on the Ugandan side. So I am now going to jump into more thematic discussions. But before I get there, allow me chip in the second should I say polling question, which we shall review at the bottom, because now that we have gotten some sort of insight on where the discussion is going, I will then chip in this second poll question. So Shiba, if you could take note, based on the discussions held, how many of us are alive to the issues discussed and have implemented them in our respective organizations? So the question is, based on the discussions held, how many of us are alive to the issues that have been discussed, and how many have implemented these issues within our respective organizations? Yes, so on these thematic areas, I will be again calling on our panelists who will be giving us insight on each thematic area. I'm going to be calling Philip first for every thematic area because I understand Philip has, I think, an overlap or clashing program coming up. So the very first thematic area is on invisible breach. What we mean by invisible breach is really many of us interacting with these AI tools do so from, I wouldn't want to say a place of ignorance, but the incidences of breach happen at a point in time when either many of us are unaware that the breach is actually going on, or what we have done amounts to an act of breach of personal data. But I wanted Philip to shed light on when data is entered, where does it, again, just to give an insight on how data is managed and handled with different AI tools, given their different capacities. Of course, general overview, and what capabilities these platforms have regarding this data, like what are the possibilities? What can they do regarding this personal data? By possibilities, I mean possibility. We could discuss both good and negative possibilities, because again, I don't want people to take away from this discussion that we are here to criticize AI and things of that nature. We are just here to open people's eyes to certain aspects regarding, let's call this managing AI, yeah? Managing AI use. That is, I could say, the gist of the discussion, because people might think we're here to criticize AI. AI is good for us in very different capacities, and I'd like to call on Phil once again to just shed light on what happens to data, that personal data that is entered into a chatbot, and what capabilities different AI tools have in regards to controlling, processing, and managing this data, both good and the negative. Thank you, Phil. Over to you.
Right, thank you. I think most of this discussion has already revolved around part of the question that you've asked. And really, as we said, is that look at this as a triangle. So this triangle, you have the data subject being at the apex of the triangle. Then one corner of the triangle, you have you as an individual or as an organization that has received personal data. And on the further or the other complementary angle of the triangle, you have the AI tool. So ideally what should happen is that you need to have express permission, as my colleague has mentioned, to process this using AI tools, especially where these AI tools may learn from this data. And so how this relationship operates is that the data subject who's at the top will give the organization or yourself as an individual this data. And the expectation is that you will handle it based on what you have prescribed. So the point where we call this a data breach or we call this misuse of personal data is at the point when now you decide to input or upload this data into a third-party system. And so when you talk about a breach in the context of the use of AI, we do not mean that the AI system or the clouds or the ChatGPTs have been breached or have been compromised. We just mean that the act of you inadvertently, without any permission or legal basis, transferring this data from a controlled environment that was submitted to you by a data subject and you transferring it to a third party in the absence of safeguards and permission, then already that is a breach that is occasioning. And therefore, it does not mean that we need to see a very big announcement on TV that ChatGPT has been compromised or Claude or whatever. But that very simple act already accounts for that breach. And therefore, it is very important. And I think this is a discussion that we've been having throughout this session, that you understand every AI platform accounts for what we call a third-party processor, processing on your behalf. And therefore, there are certain requirements, and I think we have belabored on all those requirements. There are certain requirements that need to be met even before you do that upload. Thank you.
Viola, allow me switch over to you.
Luis, just one last thing. Yeah, I think I'll be dropping off shortly, so I can maybe just give a parting shot. And I really want to, but there is an overlapping engagement here. So I also just want to appreciate the team for making organizing this. And I think a lot of what David has said was also something I was going to hint at, especially with respect to cross-border transfer of data. If you look at the 4 East African countries, of course, at this moment, Burundi has not yet enacted a data protection law, or it's still in the formative stages. If you look at Kenya, Uganda, Rwanda, and Tanzania in terms of strict regulations with respect to cross-border transfer of data, we would rank Tanzania number 1. Rwanda for such a long time was number 1, and David would agree. But then they were overtaken by Tanzania very recently as Tanzania began to, have the regulations and have processes in place. Right now, you look at how and the obligations you need to meet in Tanzania for you to do cross-border transfer of data. It's a bit chaotic. And so we are looking at a time or forward to a time where us as practitioners collectively will come together and say, look, this is making business hard in the region and we need to have a harmonized framework. And I know there are very many conversations around harmonization across the region, such that the next time we'll come to such a webinar, we'll be talking about a conversation towards having one framework that we can utilize across the region. We can't say that you're part of the East African community and then we have stark differences in cross-border transfer of data. I mean, it shouldn't be stark differently for someone to transfer data from Uganda to Rwanda and vice versa. And you see, so having adequacy decisions, of course, would be one of the steps towards that. But I think my takeaway from this conversation is we are geographically very close for us to have stark differences in the way we handle this cross-border transfer of data, to the extent that you look at regions like the European Union and how many countries are within that, and it also extends to the European Economic Area, even countries outside the EU, but have one single GDPR that allows them to transfer data within the region. So I think as practitioners, that is something we can ponder on, even as a takeaway home from this. Otherwise, thank you very much for having me. I hope to be on this show again and to just continue the conversation on data protection and AI. Thank you.
Thank you, Phil. Yes, Viola, you Still with us? Yeah, I can see you there. Yeah, Viola, allow me just take you back to, again, your field of expertise as a data protection officer. Of course, we gave scenarios where we upload as employees customer data or information into AI tools for example, to help us say draft a demand letter or different things. From your point of view and standpoint, at that point where I upload that data into an AI tool, you could just help for the listeners on call to explain at that very point what just happened in terms of management of personal data. What things have I gone affront of, and what should I have done first before I rush and upload information onto, for example, ChatGPT or Claude to help me process it in whatever manner I might need. So just help for the listeners on call to understand what happened in terms of the breaches I have made, and what I should have done prior to putting that information onto the AI tool. Thank you.
Thank you, Lois. I like that you've asked that question, and maybe it will keep all of us self-aware going forward regarding what happens when data has been uploaded into an AI tool. So what happens is you have provided this data to a third-party processor, like Phil had already mentioned. We've not looked at the data processing agreements with this third party. So this third party could as well transfer this information to someone else. So we, in that case, need to look at the safeguards that we can do. As we had earlier on mentioned, we need to identify the data that is going to be uploaded into these AI tools. You can map it, map out what is sensitive and what is not. Like Philip had already mentioned, you can annotize it. I previously mentioned if there are photos attached to the data, you can remove it. And also establish the purpose for this data. Why are we lawfully uploading this data? Are we required by a regulator like you, Louis, or we are doing it just to get a quick response? Then we determine the parties, who is the controller, who is the processor, and who is the sub-processor. Adela on mentioned assessing the risk, conducting a data protection impact assessment report, and also reviewing the contract securities and the confidentiality agreements and the consents in this data, if it has those, or if it doesn't, we'll look at our privacy policy. And what we can also do is train the users of these AI algorithms, meaning that we would educate the whole organization and just not specific employees on what to do. For example, if someone wants to use an unapproved AI service provider, like Phil had mentioned, you'd look at the permissions. Are you allowing this AI service provider to process all the data? Are they going to retain or have this data on their systems for 6 months, for 3 months? So all those trainings are required before an organization can go on to have these AI tools implemented. Over to you, Louis.
Thank you, Viola. Thank you for your insight on what would be required of us at the point when we are handling personal data vis-a-vis use of these different AI tools. So I'd like to call on David just to, again, from a practical scenario. Of course, AI tools keep evolving. Some of them have come on board when we have received client instructions. For example, I'll give an example, the divorce file we were talking about. I, for one, had a divorce file that I received, and before ChatGPT really proliferated the market and we all started to use it, and before Claude. So in a scenario like that one, what changes in terms of my relationship with this client data, and what must me as a lawyer be mindful of going forward regarding how I handle this data vis-a-vis its use with the different AI tools. Remember, at the time I got this file, we had not yet adopted ChatGPT, we had not yet adopted Claude, but now that it's here, I am now using these AI tools to help me better serve this person. So what would you advise as to the things that now need to change in terms of how I handle this client's data, and what do I need to be mindful of going forward? Thank you.
Thank you, Louis, for that question. I've already mentioned some of these things, but I think just to drive the point home, and I think what's important for us as lawyers to understand the difference between, first of all, what is normal data that doesn't qualify as personal data, then what is personal data, which we've described over and over, and then what is sensitive data. So again, I'm speaking specifically regarding Rwandan law. But sensitive personal data is information revealing the race, the health status, the criminal records, medical records, social origin, religious or philosophical beliefs, political opinion, genetic or biometric information, sexual life, or family details. So that means if you're dealing, again, if we're to use that example of a divorce file, depending on what the arguments are, you realize you have most of the information I've listed there. Someone may be reporting their spouse that they were convicted for this and that's a criminal record. They may be saying that their ground of divorce is because this and this person did this, or maybe they might narrate in their affidavits a situation whereby their loved one maybe fell sick, and in that process, they let you know what disease this person has. That's all sensitive information, and it carries a huge liability. So I'm trying to say that the information that lawyers are dealing with falls into those special categories. What if there's a minor involved, especially when, for instance, people are battling about custody? Do we understand what the data protection laws require from us when there is personal data of a minor involved? And I think that's the best way you can answer yourself. Again, I don't want to give you hard answers right now because it depends on the jurisdiction where you're sitting, and I can only speak for Rwanda. But what I can let you know is that most of that information that is in, for instance, a divorce file is not just your client's information. And while I tell you that, yes, you may beat compliance by simply having the lawful basis of the data subject's consent, if your particular client, let's for instance say it is the husband who has petitioned for divorce, if your client is the husband and they've consented as far as their personal data is concerned, they cannot consent on behalf of their wife, who is in this case maybe the respondent to the petition. Their information is involved. The personal data of their children is involved. Has there been consent from them? How do you get consent from a minor as far as data protection is concerned? So when it comes again to law firms, the data that we are handling is so sensitive that it involves different parties whose consent, just like you mentioned earlier on, is not easy for us to obtain. The best way that we can remain compliant, again, involves all the 5 steps that I already mentioned. Yeah. And I think the questions that we need to ask ourselves, first of all, us as a law firm, are we in line with the data protection law? So it will easily take you back to registration, a lawful basis. And since I've mentioned now that consent is not the best lawful basis when you're handling such matters, you then think about the other grounds. What are the other grounds? Is there contractual necessity? Many times you sign a contract with a client and the client is asking you to fulfill certain obligations. In order for you to fulfill those certain obligations, for instance, provide them with a legal opinion, yeah, you are definitely going to have to use their personal data. So for contractual necessity, you realize there you have a ground. But what if there's no contract involved? Is there a legitimate interest? Does that legitimate interest serve the data subject? Don't think about it as you, the data controller or processor, but interest of the data subject. There are other aspects of compliance that we cannot properly list in a webinar as short as this. And this is the reason why regulators such as yourself are campaigning for data protection trainings to continue. So as much as you're having AI trainings in your law firms, have you thought about having data protection trainings as well? If you think about it, when it comes to the rights of the data subject, one of the principles is that does your data subject, as a controller, does your subject know what their rights are? Have you let them know these rights? You know what the rights involve? Yeah, the rights involve letting them know that you have their personal data, letting them know the purpose for which you're collecting this personal data and what you're using it for, letting them know whether there is a third party involved as far as their personal data is concerned. So, for instance, now when you bring it home, when you bring it to this discussion and artificial intelligence tools, do they know that you're using their personal data in those tools? That's also a right that they must know about. Yeah. Do they know that they have the right as much as they consented before? Do they know that they have the right to withdraw their consent? These are all principles that you must align yourself with in order to be truly compliant. One of the easiest ways to make sure that you're doing so, again, is by having a policy. I think the takeaway from this conversation is that yes, you may have one policy to cover both personal data and AI aspects of it, but I think it would be better to have both. You have a data protection policy, and you also have an artificial intelligence policy to help you cover artificial intelligence aspects. And then I think maybe I would not be doing you a service if I did not help you consider which ones, as law firms, which ones would be the right tools. And again, I am not here to sell any particular tool over the other. So I'm not trying to say that one provider such as Claude is better than the other one, but there are certain questions that you can ask yourself, and there are 6. So I've written them down, and I hope that maybe you can take note of them as well. Questions that you need to ask yourself: does this tier, and by tier I mean subscription, does this tier use my inputs to train models by default? And where exactly is the setting? What do we mean by default? I think one of the questions that you asked Philip was on privacy by design and what privacy by design means. Privacy by design, if you think about it, most of these tools will come by default. Even if you're paying, they will come while the setting is already on. It is okay to use your data for training their models. It is upon you to go into the settings, figure out where that setting is, and take it out. That means that privacy by design was not inbuilt in that model. And this is common. I don't want to mention any names, but if you think about it, maybe ChatGPT will come when automatically they use your data. Even if it's Claude, I think Claude, I've seen some of the policies changing whereby the setting comes when it's turned off already, right? And you can turn it on or turn it off, basically. But what we mean by privacy by design is simply that some tools come when they have privacy already at the heart of how they are built. But I will assure you, most of these artificial intelligence tools are not built in that way. And even if they are built based on privacy laws of countries that your country does not fall under the jurisdiction, based on laws that your country does not follow. So it's still up to you. So that first question, does this tier use my inputs to train models by default? That's what we mean by default. And where exactly is the setting? The second question is, what is the retention period? And can I set it, or does the vendor set it? What is the retention period when you share information with ChatGPT? What is the retention period? What I'm trying to ask is, for how long will they keep your personal data or your data subject's personal data after that one chat that you have asked? You've asked the question in one chat, you walk away, you leave the chat hanging in your history. How long are they allowed to keep that data? Do you know how long the terms of GPT allow you to retain data? That's a question you need to ask. Obviously, you cannot set that time yourself, but understanding what your laws require as far as retention policy is concerned is also a step towards compliance. Third question is there a data processing agreement available to me, and does it list sub-processors? Yes, there might be a data processing agreement available to you. No, it may not list the sub-processors because some of them come as and when they are required, so you can never know. But if you're considering yourself as a data subject, you have every right to reach out to whoever it is, whether it is OpenAI, whether it is Anthropic, whether it is Meta, doesn't matter. You can reach out to them and ask them for your personal data. You can ask them which third parties are involved in your personal data, and these are your rights, whether it is under the GDPR, whether it is under the law of Uganda, whether it is under the law of Rwanda. Those rights remain. Luis, I see your hand is up. Let me just finish the questions and then I hand over back to you. The fourth question is, where is the data physically stored, and is any residency option offered? This is an important question as well. Do you know where ChatGPT stores its data? Now, the fifth question is, can human reviewers read my content or not? I think that one we've already answered, depending on the tool that you use and the tier that you're using. Then what is the governing law and the forum? I think those are the most important questions. And once you answer those questions, first of all, the answers to them can easily go into your policy, your AI policy, and then your AI policy informs all these other things like your data processing agreements, your engagement letters with clients, and any other way that you request for consent from data subjects.
Thank you, David. In the interest of time, I seen you had also touched on an aspect of the cross-border management of personal data. So allow me just shoot you a follow-up question. Yeah, most of these AI tools, come with standard terms. So from and these terms more so govern how this data is processed. And I wanted to find out from the Rwandan perspective, do you find many of these terms to be satisfactory to NCS's, should I say, regulatory regimes or standards? Do you find that the terms in these different, be it Anthropic or those different AI providers, are their terms usually aligned with what is required from the Rwandan data protection?
Yeah, thank you, Louis, for that question. Well, it's very easy for me to answer from the Rwandan perspective, and I think that the simple answer to your question is definitely no. Yeah. As again, just because these platforms are abiding by the GDPR does not automatically make them compliant with data protection laws in Rwanda. Now, the National Cybersecurity Authority of Rwanda publishes different guides that help you read the law and understand what compliance actually means. One of those guides includes the guide for standard contractual clauses that should appear in your data processing agreements. We've been mentioning that there should be a DPA or a data processing agreement between you and these, for instance, AI tools that you're using, right? But there are certain clauses that the law requires that should exist in that data processing agreement. One thing that we've already seen is that you, as the user or as the customer, you have no room to negotiate this data processing agreement. And simply because of that, automatically means there are certain things or certain gaps in those terms and conditions of those tools that cannot fulfill the terms required by the National Cybersecurity Authority. Some of those clauses include the fact that the governing law should be law number 58 of 2021, the law governing personal data in Rwanda. But obviously, I don't think your agreement or your terms with GPT say that the governing law is Rwanda. Impossible. Secondly, I've already mentioned that when it comes to cross-border data protection and process and how you handle data across different borders, in order for you to transfer data outside of Rwanda, you need to have authorization from NCSA. The question is, does OpenAI have that authorization? Do you have that authorization to share it with them? What about storage? I think storage is also another important thing. We've talked about how the national AI policy is forward-looking and sees a situation whereby we're going to have to audit different cloud storage services and ensure that they are compliant with data protection laws, but that is the future. How does it stand currently? Where does OpenAI store their data? Do they have authorization? And if they're dealing with personal data of Rwandans, do they have authorization to store it outside of Rwanda? Because I don't know whether they have authorization, but I know for a fact that they don't store their data here in Rwanda. And when it comes to storage of personal data in Rwanda, the primary rule is that data should be stored primarily here in Rwanda. The only way you can store it outside is by getting authorization. So already I've mentioned 3 areas where those terms in those different tools and platforms do not align with our law. The other areas include retention. Definitely, I am certain that the retention periods, if you even know them, of those different tools are not the same as the ones that are required by your regulator. Yeah, these are all things that we're going to have to deal with policy-wise in the future. But as we speak right now, there's a law. As much as there's no law on artificial intelligence, there's a law on personal data protection. And again, I answer the question as simply as I can. No, the terms are not in line with the Rwandan law.
Thank you, David. Viola, just a question for you. So we seem to be coming to a sort of, I don't want to say conclusion, but we seem to be coming to an understanding that it is difficult to run a full legal review or due diligence on every provider. For example, if I wanted to use an AI tool, it might not be possible for me to run a full entire review on OpenAI or Anthropic. So from the from your perspective as a data protection officer, what is realistic, and what would be the more compliant way of using AI tools? Since I can't do a full legal review on each party, what would what would be the best and most compliant way of using these tools, given that reality that it's impossible to review each individual? Thank you.
Thank you, Louis. The most realistic way of using these data protection tools is creating the awareness that the use of these data protection tools should be as a way of living. For example, if we all realize that the company or the law firm that we work for requires Claude to undertake their assignments, we shouldn't, first of all, cast the use of AI. We should find ways of adopting it. That would mean including the data protection officer in the day-to-day adoption of these policies. So we shouldn't wait for something to go wrong or for a breach to happen. We should highlight the adoption to this data protection officer to guide on the clauses we've mentioned, the retention, storage. Do we have a data processing agreement with them? Can we transfer, can we really transfer this data to this AI tool, or we would need them to first comply with the registration with a data protection office? So it's basically having compliance as a matter of practice, reminding yourself every day that before I include personal information in a report that I'm going to upload onto an AI chatbot, I should check myself. Thank you, Louis.
Thank you, Viola. Just one more question from me. Again, some of these questions are coming from the fact that our data protection law in Uganda requires that organizations do have a data protection officer. So it then for many employers, it then puts into their minds that this is a person with specialized training who knows and appreciates the value of personal data and its management. So largely, majority of these questions are around that. So I have a question that would focus more on the processes that data protection officers take into regard when say, for example, the organization decides to adopt an AI tool. What are there any processes that they're supposed to, the data protection officer is supposed to maybe say bring to the attention of management? Are there any particular steps that they're supposed to tick off before this tool can be used at the workplace? Maybe you could shed light on that. Thank you.
Thank you, Louis. We've generally discussed them, but I'll just give very brief pointers regarding this. One, look at the AI policy that we have or that you will need to create and what is required of it. Then the use of approved tools. Which tools has the company or has the law firm agreed to use? Data classification, what data should be provided to the AI tool and which one shouldn't be provided? Confidentiality rules, specific treatment of client personal information, which as we've agreed should be anonymized and say pictures taken away from that data. Then also vendor due diligence, like we had previously discussed. Do the vendors have third-party self-assessment kits that could inform you of where they store this client data that has been obtained? Then contractual protections like confidentiality, deletion, breach notification, and restriction on secondary use. Then also we need to emphasize the use of human oversight. We realize that most of the times when we use these AI tools, we leave the decision making to them. Can I legally use this argument? And you just go with the argument, but it is mandatory that we consider the human oversight over these AI models. Then also having an audit trail, keeping records of significant AI-assisted work and the implications of this work, and also training of employees and lawyers would also help to ensure that the staff know what should be done. And then companies should also provide for an incident management procedure. This could be provided for in the AI policy or even in the data protection policy, because this would cover both of them. So how do we handle procedures? How are they reported? If it's a breach, how do we provide a report that is to be shared with the data protection office? So those are the 10 items that I believe we should all take note of.
Thank
Back
you
to
very
you,
much.
Louis.
Thank you very much. I just wanted to this question, I think, is to David and Viola. You could both give us your view on this regarding automated decision making by AI bots. And basically, what is automated decision making under the law? And when does AI screening or scoring cross into obligations organizations are ignoring? In other words, when AI is processing personal data, at what point in your experience do you think it skips or goes into an area that organizations are not, or its users, let me put it that way. At what point does AI go into for lack of a better word, at what point does AI then get into a field that its users are not paying attention to in terms of say compliance or handling personal data? Thank you. Oh, I have a hand from Shiba. Yes, Shiba.
Apologies, it was a mistake. You can carry on.
Oh, sure.
Yeah.
All right. Thank you, Shiba and Louis. The distinction I would make is between an AI being used as an assistive tool and AI being used to make or materially determine the decision about a person. For example, if AI helps a human resource department organize applications, but a human being independently assesses the candidates, that is different from an algorithm scoring of applicants and automatically rejecting them. Like I'd earlier mentioned, Uganda specifically gives a data subject a right to require a decision that is significantly affecting them to not be based on automatic processing. So where such a decision is significant and it's solely based on automated processing, the controller, meaning the person who has included this information into the AI system, must notify the data subject, and the data subject can require reconsideration where the statutory framework requires it. For example, if I've not scored highly at an HR assessment, but this is based on an AI, then I should be informed, and also an appeal process should be provided. So organizations need to ask, what role does AI actually play in the decision? If AI is simply assisting a human, the legal analysis may be different from a system effectively making the decision itself. But where there's a human in the loop, organizations should not assume that simply clicking approve makes the process genuinely human. If the human is merely rubber stamping an algorithmic output, the organization should consider the substance of the decision-making process rather than the label.
Thank you, Viola. I don't know if David is still with us.
Yes, I am. I completely associate myself with the submission of Viola on that one. Maybe just to add, because I think that we should put emphasis on the word solely based, right? Because the law says that one of the rights of a data subject is not to be subject to a decision that is solely based on an automated process. So because you want to be compliant, you're definitely going to put a human being in front of the computer to simply click yes and confirm. But what we mean here, and it sort of relates to ensuring that there is always human oversight on these machines, is that the person who is manning these tools, like for instance, the HR tool, is not simply accepting what the AI says. Because as soon as your job is to simply say that, oh, okay, the AI has said David is the best performed application, let's take that. Louis is the best, and you're always just accepting what it says, then you're not complying, because that would mean that you are solely, that decision making is solely based on the automated. The law requires involvement of the human to the point of you actually question whether this decision it has made is correct or wrong, depending on what you're using it for. That's all I would add to that.
Thank you. Then I just have a thought-provoking question to all of us, myself inclusive. If regulators, enforced robustly against non-compliance in terms of AI use and data protection, would that slow down or negatively affect the adoption of AI? I don't know, maybe David, you could give us your view. I could come after you or after Violet.
Yeah, I can try and take that, Louis. I feel like that's more of your question, and I'm obliged
Sure,
to whatever you add onto it, Mr. Regulator, sir. But to be honest, from a perspective of a person who's always advising people when it comes to data protection compliance, you realize that actually, yes, the biggest fear is robust enforcement. Because when you look at the sanctions when it comes to enforcement, and you just imagine, okay, what happens if implementation, and correct me if I'm wrong, I understand that in Uganda, in Kenya, implementation of enforcement is really ongoing. But I also know that Rwanda is taking the approach of continued campaigning for people to understand this. And so I'm not saying that implementation of enforcement is not yet here. That's not what I'm saying, but I'm saying that it may be slower because they are trying to let people catch up. I sort of have, sort of like prefer to think that that is a good way of doing things, as opposed to maybe scaring people outright. Because even just having this conversation about whether you are breaching AI laws when it comes to data protection, someone who is not properly listening to the conversation and goes away with anything might think to themselves that, oh no, we've been asked not to use AI tools in our work anymore. No. I'm also seeing a question from an anonymous attendee saying, is it enough as a protective measure to include a provision in the letter of engagement that you will use artificial intelligence? Again, no. We're not giving you tricks to reach compliance in 2 seconds. No, compliance is, as Louis, you understand, compliance is a way of life. Compliance is how you handle data from the point of collection to the point you get rid of it. So putting that in your engagement letter, I said, is a first step, and it's a first step towards disclosure, which disclosure will sort of require consent from the data subject. But in no way should you think that it is enough. No, that's not what we're saying. But again, there's a lot of fear from the side of the customer, from the side of data controllers, that the enforcement is just making them hold back on how they use the tools.
Thank you, David. From a regulator's perspective, whether robust compliance affects adoption and use of AI, it goes twofold, because also as a regulator, you have to appreciate that you carry a responsibility, you carry a duty. You before the citizens of the, be it Rwanda, Uganda, Kenya, whatever the case might be. If you're a regulator in those different jurisdictions, you do have a responsibility that you owe to the citizens within that jurisdiction in terms of how their data is protected by the state. That is a responsibility that has been handed down to you. So it is a balance that regulators have to strike. What do I mean? PDPO, that's the Personal Data Protection Office, is of course, again, just like my brother stated in NCSA, it is also an office under NITA, just like it is with Rwanda. The Data Protection Office might be, I think, a department within NCSA. Yeah, so that being said, we are also adopting a more friendly approach. In other words, yes, decisions have been made, and many of them are binding on the parties, because of course also the Personal Data Protection Office has a complaint handling function. So yes, and as far as handling complaints and implementation of those has been done, that one you could argue that we are aggressively implementing the act, but we also have a more friendly approach. In other words, we are still calling on people to be compliant, because we do appreciate that majority of non-compliance is really arises from the awareness, the knowledge gap. People are not really being non-compliant because they don't want to. It's because people have not yet appreciated or understood that their personal data is of value to them as individuals or themselves as data subjects. People have not yet valued that their information can be used or manipulated by different people for different purposes. So we are still trying to push, to campaign, to again, I thank our hosts for giving us this platform, because again, this also allows us to continue to push out our mandate out there and call on people to register, and also those who are into data processing, to see to it that they are all compliant with the act. So we are not going about this in a, how do I call it? We are not aggressively implementing the act. Well, yes, we are, but we are also coming at it from a place of trying to encourage registration and compliance. So Yes, it's a twofold, because we also don't want to affect the adoption of technology and AI, because it is something that we're going to live with. It is something that's going to push productivity of economies. So they are very necessary tools, but the manner in which they are used is what we are trying to get people to appreciate, more so the risks associated with poor usage of or unregulated usage of these tools. Yeah, so I'd like to, we're being caught up with time, but allow me jump to the Q&A session so that we can hear from those on call, and then we can go back to the poll results after. So I'd like to ask Shiba to advise on how to go about the Q&A session. Do people have to raise hands and we give them audience, or? Thank you.
Yes, Louis, thank you so much. Because of time, we may not be able to answer all the questions. I already see some questions in the private chat, and I don't know if you have access to them, Louis. See that. You can choose 2 questions to ask to our panelists, and then we move on to declaring the poll results. Are you able to see them?
Oh, sorry, I had not unmuted my mic. So I'm seeing the
Oh,
question.
yes. So I suggest you pick 2 due to our time constraints that our panelists will answer. Then the rest of the questions shall be answered on our social media platforms. So I'll urge everyone to look out for that. But because of time, we can only answer 2.
Okay. I have a question from Amumpire Doreen. Where in Uganda can an aspiring data privacy officer obtain comprehensive training in data protection? It may be an accredited institution or trainer, and what is the duration of this training? Then let me look for a second question. Don't seem to see any other second questions.
There are some, Louis, there's some questions in the Q&A section. I've already answered one of them regarding, is it enough as a protective measure to have provision in a letter of engagement with the client stating that you from time to time use AI to perform legal services under the engagement efficiently, which may involve processing their personal data, and that you undertake to process the data in accordance with your policy and the relevant data protection laws from an anonymous attendee. I've already said that this is a very good first step towards disclosure and obtaining consent from the data subject being your client, but in no way should it be considered as enough, because if you've been listening, we've been trying to mention all the other things that bring you to compliance. But yes, this is a very good first step. It's not enough. And then the second question, I think from another anonymous attendee, I think we can just handle that, and it's Shiba, you can maybe choose another question, but this will be the last one I handle. Correct me if I'm wrong. Correct me if I'm wrong, from another anonymous attendee. Correct me if I'm wrong, a data breach will occur where the data then has identifiers, and the identifiers then can be traced to a specific identifiable individual. Would that then mean that in the legal perspective, if an advocate were to anonymize data but use the facts to research, then without risking a data breach? And the answer, if I'm understanding your question correctly, is yes. Again, when it comes to anonymization, I think Viola is the one who mentioned this. Once you anonymize your data, what are you doing? You're taking out the personal identifiers, right? In other words, when someone looks at that anonymized data, they cannot tell who it relates to. So for instance, if there's a name, you remove it. If there's maybe their position in a company, you remove it. If there's a telephone number, if there's an identification number, maybe a passport number, anything that can be used to identify someone can be removed. And that's also what Philip was referring to as reduction. So if you take your time and frame your question by redacting certain personal information, essentially, you are anonymizing it and taking it out of the ambit of the data protection law. Because as long as it's not personal data, then there cannot be a personal data breach.
Thank you very much, David. I don't know. There's a question from Maria Kate Nanyonga. Had it been answered on how to use Meta AI on WhatsApp?
Sorry. Okay. All right. I intentionally avoided it, Viola. So wonderful. You can take it on.
Yes, and this is exactly where I would be cautious if an app doesn't have a direct privacy policy, especially if you're looking at Meta from the data protection or corporate use perspective. The key is that Meta AI is an inside app, it's a WhatsApp. Does not mean it inherits the same privacy treatment as an ordinary WhatsApp conversation. Meta itself distinguishes between ordinary WhatsApp communications and interactions with Meta AI. The first distinction the first distinction between WhatsApp chats and Meta AI chats is ordinary WhatsApp personal messages and calls are end-to-end encrypted. You will see that privacy notice in your chats when you get a new contact. It will show you that this is end-to-end encrypted. But when you deliberately interact with Meta AI, you're sending information to an AI service for processing. So Meta's own material says that Meta AI can process the prompts and other information you provide to it, and that it can also use the context for interaction in the near future. So this is particularly important because the user may psychologically think, I'm still using WhatsApp. This is covered by WhatsApp's normal privacy notification, which is not the case. So Meta also says that the AI cannot simply read everyone's WhatsApp conversations. In a group conversation, for example, Meta says you need to explicitly invoke Meta AI, and Meta AI does not otherwise have access to the communications between the members. I hope I've responded to that effectively. Lewis?
Oh, thank you. I also wanted to, she seemed to talk of a privacy policy. I think Viola seems to be more grounded on the workings of Meta AI, but I'd also like to, I don't know, this is just my personal opinion. Some of these apps, Meta AI and WhatsApp could be owned by one and the same person. So you might find that because you took on WhatsApp, its terms of use or terms and conditions, which many of us don't read anyway, could provide or give room for WhatsApp to come up with new products, or I'm saying new products, but I mean things like offering you AI tools and things of that nature. So by virtue of the fact that you're using WhatsApp, you could still use that Meta AI. That's why I think you might not have seen the direct privacy policy, but I think if you did enough digging, I'm sure that information is available. Yeah. Thank you very much. Let me just, oh, there was also a question, Viola, on the training that a data protection officer undertakes. You could shed light on that so that somebody could also aspire to be like you one day.
Well, I should say at first it was learning on job. You read the Data Protection Act and you implement it. But later there was a training that was organized by the Gap Management Institute. I'm not sure if they still have that training, but you could look it up. But out of Uganda, I have obtained certification from Strathmore University. This is in Nairobi, but they have an online training, or you could also move there to get that training. They had one about 2 years back. I think there's one that was also rolled out this year. So you could take note of Strathmore University and Gap Management Institute.
Thank you very much, Viola. Thank you all members on call for the questions. I'm just going to go back to the poll before I could have our panelists give us their parting shots. Shiba, you could help us pull up the...
Yes, yes, Louis. I don't know if the ELS team can help us pull the poll results, but they had displayed earlier. Maybe as we wait for them, I can just give you guys the result as is. So in our first question, I hope everyone can see. We had, have you ever used AI to simplify or improve your work? 88% of the people said yes, and 12 said no. I don't know about the guys who said no. I doubt that response, but okay. Then for the second question, yes, we asked, based on the discussions we've had today, how many of us are actively aware of the issues discussed and have implemented the recommendations? So 33% of you said yes, I'm aware and have implemented them. 30% said I'm aware, but I haven't implemented them yet. And 37, I'm not yet fully aware and I haven't implemented them. Wow. Okay. So I'll leave it to interpret.
Interesting data. So I think that poll kind of sheds light on our very first question that I had shared with Viola on what or why we are having issues to do with compliance. You can see it is really an issue of knowledge. Yeah, because if you see, we had 37% being the highest figure on the because the rest was, the first was 33, then 30, and then 37. 37 was on, just for clarity, that was on the second poll.
7, yeah, it was on that second poll.
Yeah, 37 were those who understood but have not implemented. Oh, they said they didn't understand. I'm not yet fully aware.
They didn't
haven't
understand and they
implemented them.
haven't implemented.
Yes,
Yeah.
so that shows you what we were saying. The first poll, I will not shed much on it because it is an admission that many of us use AI. But now the second poll is the one that helps us come to some sort of deduction. So we have majority of 88% people who attended the call use AI, which is a huge number. And you can see that those who are aware and have implemented are 33. Then those I am aware, but I have not yet implemented are 30%. And then I am not fully aware or haven't implemented them are that. So that is the biggest number, those who are not aware. So I'd like to personally, as a moderator, thank Caven Bridge and ELS. Sorry, it is Caven Bridge Advocates and the East Africa Law Society for this webinar. Because again, this helps us plug that knowledge gap that we're talking about. So I guess maybe if we are to do another poll and have the same audience, hopefully that 37 might come down to like a 2 or 1%, which shows that we are actually having some actual impact on these webinars and not just racking up the numbers. So I'd like to thank Shiba. I'd like to thank our hosts for this opportunity. I'd also like to thank the panelists, Philip in absentia, Viola and David, for sparing time in the afternoon to give us an insight on this area of the law and practice that they appreciate so well. It has been an honor. I remain Louis. I am not a regulator as said. I work with NITAU. The regulator, I work closely with the regulator and sometimes I support them because what people might not know is also the regulator has challenges. Some of them are resource constraints. So yeah, we do step in to fill the gap where we are needed. So Thank you very much once again, and allow me hand over to our host Shiban again. Thank you.
All right. Thank you so much. Thank you so much, Louis. You've done a wonderful job. And I think all of us can say that we have learned more. Personally, I am leaving this place with more knowledge. I really thought I had covered that entire area, data protection, but there is more to learn. And given the poll results, it does show that we need more conversations like this, because there's an overwhelmingly huge number of people who actually are not aware of some of these facts. So as beyond the bar, we shall be having more conversations like this. I'd love to thank the East Africa Law Society for engaging with us and hosting us in this webinar. I'd love to thank our partners, Trust Law Chambers Rwanda. Thank you so much for all the support that you've given us. And thank you to our panelists, Viola, Davis, and Philippe Absentia. Thank you so much, everyone. We apologize for the questions we haven't yet answered, but please keep a lookout on our social media pages. We shall be answering the questions that were missed. So please don't lose heart. And we shall also be sharing the recording. For those who missed, you can share with your friends who missed out and find some interest in the topic. We shall share with you the recording. Thank you so much, everyone. See you next time, next month for the next webinar. Thank you.
Thank you, Sheba. Thanks, everyone.
Thank you, Shiba and the team.